with what turned out to be a frivolous issues about to empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Kerugoya, whereas the court in Kerugoya fixed a date for the application now before you, it did not fix a date for the application now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were to hold, my lord, we too, the party representatives, filed a PO, and you've not heard me telling you that that PO should start. I'm just following the directions being given by the court. And when all is said and done, my lord, the Swahili say, akili ni nywele, kila mtu akona zake. Nobody needs a brain in this court to know that the reason for all these dilatory tactics is because this side believes, having obtained a final ex parte order, they can now grind the wheels and backpedal and buy time until the conversion of the Jews, or until, as my people say, donkeys grow horns. The court must rein in these tactics.
My lord, permit me, please, to object to the term frivolous. We have been raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senator Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima, and my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, a PU. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and 2 others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
Counsel, we don't use that kind of language. I think Senior Counsel Paul Mutu is right that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed. Applicants.
My Lord, I was on my feet. This is on behalf of the petitioners on the issues of time allocation. My Lord, the respondents have, throughout this matter that has been going on, sought to have a time allocation scheme whose effect would be to guard the petitioners from presenting their case. My Lord, in the normal course of things, and this is a bench, one of the 50th or 70th bench that we are appearing before, the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been what is the estimations of the advocates of the time that is necessary for them to do fair representation within the minimum of Article 50 of the Constitution. My Lord, we are here, we know the urgency of the matter. But as petitioners, on that issues of time allocations, the petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they're not enough, we will consider. We're here. We shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish. The problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
May I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongaya, please sit down. Let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you so much, my lord. That's an impressive direction.
My Lord, Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, what is being preserved is the right, constitutional rights of the deputy president who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory orders, or 2 judges issued conservatory orders. But my lords, your ladyship, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter so that the deputy president remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. My lords, the weighted issues identified by the three judges are: one, the issue of public participation. The petitioner here says the public participation was a shadow of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist in his place. Our opponents will be pointing out to you where it is that undermining the President is one of the grounds. My lords, the people of Kenya, in retaining sovereignty in themselves, elected leaders, members of Parliament, senators, Deputy President, the President, to serve them. They are the employers, the deputy employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the Deputy President and the President and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague, Elisha Ongoya.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024, we adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled petitioners' submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs, and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, we were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is announced. I have alluded to transparency.